Hi, and welcome to the Chapter 45 Rules Training. We are going to be covering Module 6, Sections 27 through 31. Module 6 covers Section 27, which is Initial Provider Certification, Section 28, Recertification of Providers, Section 29, Corrective Action Plans, Section 30, Sanctions, Section 31, Relative Providers. So we will go ahead and start with Initial Provider Certification, Section 27. An individual or entity may apply to become a provider by completing the division's initial provider certification packet and all required trainings. Evidence will need to be supplied that demonstrates that the applicant meets all of the necessary qualifications for each service in which the applicant is seeking waiver certification. The division shall initially certify a new provider agency for 1 year. The agency must complete an on-site recertification at the end of the first year to continue providing services. For general provider certification, you would go through Mark Sparks, and for case managers, certification is done through Jennifer Adams. Continuing on with Section 27, Initial Provider Certification, if the division receives information that the provider no longer meets the qualifications for each service in which the provider is certified, a notice will be sent to the provider within 1 business day regarding the missing qualification and applicable sanction. If the missing qualification is not obtained within the time frame given, the provider will be disqualified from providing such waiver services. Continuing on with Section 27, Initial Provider Certification, the division may refuse to certify or decertify providers under the following circumstances. The person or entity has an open or pending corrective action plan with the division. The person or entity has any open cases with the Medicaid Fraud Control Unit. The entity has an officer, administrator, or board member previously sanctioned by the division. This refusal applies to a period of 2 years from the date the person was sanctioned. Or the person or entity fails to disclose any conviction in a court of law on the provider application or organization's application. Any falsification of statements, documents, or any concealment of material fact may result in a denial of certification, subsequent decertification, or referral for criminal prosecution. Section 28 covers recertification of providers. The division will recertify providers on an annual basis. The division will notify providers at least 90 calendar days before their certification expiration date. The notification will include what requirements the provider must meet for recertification. All first-year or initial certification will have an on-site visit for their first recertification. All recertifications, if delivering services in the provider's location after the initial year, may have desk audits in lieu of on-site visits for up to 3 years. The purpose of the recertification is to ensure compliance with the Chapter 45 rules and the program. Continuing on with recertification of providers, what is a recertification? Provider will submit evidence of compliance with the Wyoming Medicaid rules and federal regulation for the home and community-based services waivers. For providers who control, own, or lease any settings, the division shall review providers' self-inspections as well as any inspection reports from outside entities. Note, at any time, the division may conduct on-site visits when a concern is identified during a complaint, incident report, or internal referral if there is indication the agency is not complying with state and federal regulations or at the division's discretion. Continuing on to recertification of providers, the provider will submit verification they have met all requirements to the division at least 45 calendar days prior to their certification expiration date. If the provider does not submit all requirements 45 calendar days prior, the division will notify the provider in writing of the expiration of certification and may grant 15 calendar days for the provider to meet the requirements. If requirements are not met after these attempts, the provider will be decertified. Any decertified provider will not be able to reapply to become a provider for 2 years following decertification. If the provider fails to meet the requirements at the end of the 15-day period as stated in the slide, again, we want to reiterate the division will notify the provider that he or she will be decertified, and the provider will need to transition all participants they serve and cannot reapply to be a provider until a 2-year period from the decertification date has passed. Moving on, Section 28 again, Recertification of Providers. The division will issue a written report of all compliance areas and any recommendations that need addressed within 30 calendar days. Any recommendations must be addressed in writing back to the division within 30 calendar days in order to maintain certification. The division may approve a certification for less than 1 year if deficiencies are identified that seriously affect health and safety, welfare, rights, or habilitation of the participant, or if the provider has substantially failed to comply with state and federal regulations. The division reserves the right to deny the provider's certification. What's next after my recertification? You will receive a report outlining the compliance and recommendations for areas found to be in non-compliance within 30 calendar days. For all recommendations identified in the report, the provider must complete a corrective action plan and submit it to the division in writing within 30 days. If serious health, safety, welfare, or rights concerns are identified, the division can issue a certification period that is less than 1 year, and we do reserve the right again to deny your certification. Section 29, Corrective Action Plan Requirements. What is a corrective action plan? Corrective action plan is a plan that addresses areas that are found to be non-compliant with Wyoming Medicaid rules during provider recertification, incident reports, or complaint reviews. The plan outlines the areas of non-compliance, action steps for addressing the areas of non-compliance, the provider and or staff responsible for completing the action step, due dates for completion, and when it was completed. The action steps do not have to be completed at the time of the submission of the corrective action plan. As you can see on the slide, there is an example of a corrective action plan requirement. So the area of non-compliance is emergency drills. The action steps are create a calendar when each drill category will be conducted, develop a process for collecting paperwork, develop a quality assurance process to ensure all drills are conducted. And then if you look to the right-hand column, person responsible, it indicates who is responsible for each action step. And then again to the right, the due date for each action step, and then the completion date for the entire corrective action plan. Moving on to Section 29, Corrective Action Plan Requirements. Corrective action plans must address each area of suspected non-compliance. This includes action steps of how the provider will come into compliance with the rule. Suspected non-compliance that is related to immediate health, safety, welfare, or rights of participants shall immediately be addressed. The provider will have 15 business days from the date a report is issued to submit their corrective action plan, but the situation must be dealt with immediately. If a corrective action plan is not implemented to address all areas of non-compliance, the division may impose sanctions. Continuing on with corrective action plans, the division will notify the provider within 30 business days after the receipt of a corrective action plan whether or not approval or disapproval was given to the plan. The division will ask for monthly monitoring by the provider to get the corrective action plan completed. This monitoring must be submitted to the division. If it is not submitted, the division can choose to sanction the provider. The division can also request follow-up or additional items during the recertification process that assures the provider has fully implemented and evaluated participant safety during the corrective action plan implementation. Section 30 covers sanctions. Sanctions may be issued to a provider for non-compliance with the rules. The types of sanctions available are listed on the screen. However, the list is not inclusive. An education intervention is required education to the provider, and training may be conducted by division staff or another entity as determined by the division. Recovery of overpayments. Referral to a Medicaid program integrity unit may be a sanction. Post-payment review of claims. Review of providers' documentation and billing information after claims have been paid. Prepayment review of claims. Review of providers' documentation and submitted claim prior to claims being paid. Suspension of payments. Payments suspended in part or entirety until all corrective actions associated with the sanction has been completed. Suspension of provider agreement. No longer considered a Medicaid provider, therefore they cannot provide services on the waiver. Conditional future provider agreement. Conditions must be met in order to provide services. This is discussed with the program integrity unit. A referral to the appropriate state agency. This could be a licensing board, medical review board, Medicaid program integrity, or Medicaid fraud control unit. Continuing on with Section 30 sanctions. Termination of certification or provider agreement. If it is determined that the provider certification shall be terminated as a result of non-compliance with the rules, the provider must submit a transition plan for the participants served by the provider to the division within 30 days of the final sanction. The plan must be approved before implementing, and transitions must be complete within 90 days of notification of decertification. Participants must also be transitioned within those 90 days of receipt of notification from the division that the provider certification is being terminated. Section 31, relative providers. This section covers the requirements for relative providers as allowed by the Wyoming statute under CFR 42, which was amended during the 2011 legislative session. The section is a new language to the rules and defines relative services that may be provided and scope and limitations on allowed services. Section 31, relative providers. So here are the definitions. In 2006, the rules under Chapter 45, Section 38, provider participation, a caregiver that is not a parent, guardian, or spouse of a participant who wishes to provide services, blah, 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 blah. The new rules in 2017 now state under Chapter 45, Section 3, general provisions that a relative means a participant's biological or adoptive parent or step-parents would be defined as a relative provider. The definition for the new relative rules, or a definition of a relative in the new rules, can be found in Section 3 of Chapter 45 if you have additional questions. Relatives as defined in Section 3 may be reimbursed for services provided to the related participant if they become a certified waiver provider and they form a limited liability company, LLC, or other corporation. Section 31E states no parent, step-parent, or legally authorized representative may be hired to provide services through self-direction. Continuing on with relative providers in Section 31, certified providers may hire relatives or legally authorized representatives to provide services to the related participant. The certified provider must have a written policy on, first, addressing potential conflicts that may arise from that relationship, and second, how the conflict will be mitigated. The policy will need to be shared with the participant and the relative or legally authorized representative. Continuing on with relative providers, What services can be provided by a relative? A participant 18 years of age or older can receive the following services by a relative provider: residential habilitation, supported living, personal care, specialized equipment, supported employment, pre-vocational services, environmental modifications. The ones enlisted in these bullets with one asterisk, a relative provider cannot live in the same residence as the participant. And those in these bullets that have two asterisks, the services cannot exceed 4 hours per day if the provider lives in the same residence as the participant. Continuing on to relative providers, this covers participants who are 0 to the age of 17. Personal care, only up to 4 hours a day for extraordinary care, must align with supports in the IPC or individualized plan of care, must meet the adaptive behavior quotient or ABQ, which is less than 0.35, and supports provider must be greater than what would be given to a household member of the same age without a disability. Relative providers who are delivering services to children 0 to age 17 may only receive payment for personal care services up to 4 hours per day for extraordinary care purposes only, as indicated in the slide. Extraordinary personal care does align with the AB quotient, or the ABQ, adaptive behavior quotient, that's also indicated in the slide. And the supports provided by the relative, which are ADLs or IDLs, which means activities of daily living or instrumental activities of daily living, have to be greater than the supports that would be given to another household member of the same age without a disability and illness, and is for their health and safety, again, as indicated in the slide. Moving on to relative providers, the case manager monitors services by a relative provider in the same manner as non-relative providers. If there are concerns with services that are being provided by a relative provider, the case manager must work with the team to determine if a modification to the plan of care is needed, which may include a change of providers. Moving on, relative providers, section 31. Relative providers or relatives that intend to provide services to the related participant have to inform the team of the relationship during the annual team meeting. The relative provider is also required to acknowledge and address any safeguards that are outlined by the division. Relative disclosure forms have been updated to incorporate the requirements in the rules. Teams must complete the form when the relative provider is added to the IPC and any time that there is a change to the waiver, service, or case manager for the relative provider and the participant. Continuing on to relative providers, so what does this look like for other types of relatives, like siblings, aunts, uncles, grandparents, step-family, a child that's 18 years of age or older of the waiver participant, cousins, or in-laws? They may still provide services to the related participants, but a relative provider disclosure form does not need to be submitted to the division. Since the rollout of the HEA 91 in 2011, the division does require all relatives do a disclosure and safeguards and acknowledgments form to be on file with the division. The rules do not include the other types of relatives that are mentioned on this slide. Because the rule is silent on these types of relative providers, the division will not require a relative disclosure form to be completed for these types of relatives after December 31st, 2017. Section 32 through 34. These sections are in every state of Wyoming rule set and will not be reviewed during this training. Our closing, we'd like to thank you for joining us through our journey of the Chapter 45 rule changes. If you have questions, please refer to your provider support specialist and they can help you out. We appreciate your time and all of the hard work that you do, and thank you for joining us for all of these modules. Have a wonderful day.